court case can be a very lengthy ordeal for a victim of crime. And what might seem normal to the lawyers involved in the process can seem like a lifetime for a victim. Sometimes, if the accused person is willing to plead guilty at the earliest available opportunity because he or she has great remorse, wants to move on, and wants to reconnect with his or her family, then a guilty plea could be entered on within a week or two of the charges being laid. It is possible that can be done, but that's definitely the exception. Even if a person intends to ultimately plead guilty, it can often be a month or two for meetings to occur between defense counsel and the Crown, for us to meet with the victim, and just for available court time, depending on the issues of a particular case. If it's going through to trial, it's not unusual that the trial occurs even 1 year after the offenses or longer. It is possible that it takes that long to work its way through the system.
I believe the justice system let me down. I believe that instead of holding someone accountable for what he did, he was allowed to say, I didn't mean to be a bad boy, and I'm really sorry. And maybe he is sorry. I don't know, and I don't need to know at this point.
Those who administer our laws, including law officers, Crown attorneys, judges, and others, may deal every day with the most brutal crimes. In some way, they have the need to build self-protective barriers, which may come across to victims as insensitivity. To help you through this ordeal, seek out supportive friends, counselors, or advocates.
When anybody reports a crime or a call for service, an officer, most of the time a uniform officer, will attend the scene immediately. They're going to assess that scene, assess the victim, provide emergency response if it's required. They may seize the scene, they may hold the scene. You often see the police tape go up. That's to secure the evidence. Probably immediately after that, you're going to start to see supervisors show up on the scene as police resources are being driven to assist that victim and also to secure the crime scene. We have many levels of expertise. We may have forensic identification officers or scenes of crime officers arrive on scene to start collecting the evidence. The police detective is going to show up on scene and initially drive that investigation.
When we go to the scene of an occurrence, we're usually the first ones there. So we have a very strong and supportive role of the victim at that time. Of course, our job is to sort things out and investigate, but we have an obligation to the victim to support the victim and to ensure that afterwards that we meet the victim's needs in terms of keeping them up to date on the status of any court cases, providing referrals and assistance at the time, ensuring that we have all the mechanisms in place to advise them later on of anything relative to the accused. There's many things that we do as police officers, both initially at the scene and then later on in our role to support victims.
The police responsibilities to the victim are endless. They were enshrined in statute in the late 1980s with the Victims' Bill of Rights, which was incorporated into the Police Services Act. That makes it incumbent upon me by law to assist victims of crime. At the same time, a number of victims groups were established in the province. They stepped forward to assist the police in fulfilling our obligation under the Police Services Act and the Victims' Bill of Rights.
It's important for police to refer victims to victim services and the other affiliated programs to ensure that victims are connected with community partners that can best see them through a process that can be extremely difficult if they're isolated or on their own. Police have a specific role in dealing with victims of crime and working often with the offender and putting them into a process and a system. Having police connect victims with community partners that can support them is probably similar to a comparison like if an offender is arrested, they immediately go to, I want to speak to my lawyer. I mean, the ideal world would be victims being aware of victim services and those kind of agencies that a victim can quickly say, I want victim services or someone to support me.
One role for which a victim of crime is responsible is in giving a statement to the police. The following information concerns the procedure regarding giving a statement, also known as a KGB statement.
A KGB statement is a special type of statement that we do. It's a videotape statement that's taken under oath. So when we bring in a victim and want to perform a KGB statement, we will bring them into a video interview room. I interview or introduce myself and explain to the person what is about to happen. It is very unnerving for any victim to sit and have a KGB statement done because there are 3 pieces of paper that I use in performing it. And I'm going to explain to you that you need to give your statement under oath or solemn affirmation. I'm going to explain to the person how important it is to tell the truth. I'm going to explain to the person 3 different criminal offenses that they could possibly commit while giving the statement. Things like obstruct justice, public mischief, lying to the police, perjury. That scares the victim. And I certainly understand why it does.
A KGB statement may be an unpleasant experience for victims, but police would like victims to be aware that the statement also has many benefits to the victim of crime.
So a video statement also assists the victim. When we go to court, in some circumstances, the Crown can play that video statement and have the victim acknowledge and accept the contents of the video statement and agree that they are true. That allows the court to see exactly how the victim was reacting, how the effects of the assault were affecting that victim that night 6-9 months ago from the day that we're in court.
In situations where a victim may feel apprehensive about continuing a charge against an offender, this statement also helps maintain justice.
It's a way of ensuring that we can do the absolute best investigation that we can, knowing that there are tremendous pressures on a victim to change their story, even though they initially told the truth.
In defining a high-risk offender, there's many things to consider. There's the fact that the nature of the offense that's been committed, the propensity of the person to reoffend, any record that they have. The perception of the victim is very important. You know, what does the victim feel about the threat that that person poses to them? Other circumstances to consider, such as whether or not there are drug abusers, alcohol abusers, you know, whether there's access to firearms. So I don't think there's, in my opinion anyway, there's really a firm definition of a high-risk offender. Rather, it's more taking into context all those things that give rise to why that person may be a high risk.
High-risk offenders would be identified through a few different means. One would be looking at their past criminal record. So we would check to see the severity, the increasing pattern of violent offenses, or if they have similar types of offenses that they're now before the courts with.
The high-risk offender on the other end could also be the person being released from a penitentiary after serving a sentence. That high-risk offender is immediately going to be released by the corrections staff. While in custody, serving his time or her time, they would undergo a number of different assessments, and those assessments will reflect whether or not they still pose a risk to the community when they're released. If they have a high risk of recidivism, to repeat the crime, then the police are notified.
Once a high-risk offender has been identified, police, as well as probation and parole, will handle the specific case more intensively when the offender is released into the community.
I think the difference in dealing with high-risk offenders than other offenders is that the reporting is more frequent during the supervision period. The referrals are prompt to address their programming needs. There's strict and immediate enforcement, and frequent communication with other criminal justice partners like police, the Crown's Office, Victim Services, and other agencies. Additionally, we have more contact with the victim.
Because the concerns of victims of high-risk offenders may be greater, the approach taken is much more involved on all levels. This includes such things as notification, reviewing safety plans, considering more intensive counseling, and offering such services as the Support Link program, which is very useful upon the offender's release.
When my ex-husband was released from jail, I knew his release date. Prior to that date, I went to the local police in the town that I was living in and said, my ex-husband's going to be released from jail, and here is our history. They had made the appointment, I had made an appointment with them, so they were able to get that history off their system. And what they did on his release day was they had, for about 72 hours around where we lived, we had patrols. I felt very safe.
The victims of a high-risk offender are going to be in pretty much constant contact with the police. They're going to be aware of the investigation that the police are doing about that offender being released back into the community. They should be kept apprised of where that offender is going to be living, where they may be working, where they may be traveling to and from, who they should be hanging around with and who they shouldn't be hanging around with. That way the victim can still identify to us whether some of these people or places that they're going are appropriate.
Risk assessment should be conducted in all crimes involving personal injury or threat. Risk assessments are conducted to understand what kinds of threatening and violent behaviors an offender has committed and may have the potential to commit again. A police officer or probation and parole officer may ask you a number of questions while conducting a risk assessment. Risk assessments may be conducted frequently. The level of risk of reoffending may change as circumstances change. If the person who has committed the crime is in jail, there is a lower level of risk of danger to a victim at that time. The risk of harm may increase when the offender is released into the community.
The risk assessment is going to be undertaken on a multidiscipline level. The police will likely head that investigation. We will seek input from victim service groups, the victim himself or herself. We will seek input from probation and parole, the corrections institution where this offender had last been. We will seek out doctors, psychologists, sociologists, anybody with expertise in the field that we are investigating, all for the hope of trying to understand this offender that's coming back into the community.
Ask a police officer to go over the results of the risk assessment with you, because often victims may not be aware of the danger they are in. This will give you both an opportunity to discuss the severity of the situation and provide better information for safety planning.
The Crown Attorney in general were the prosecutors of crime. So a file, once the charge has been laid by the police, comes across our desk and we have to screen it. So we have to look to the file to see, is there a reasonable prospect of conviction, and is it in the public interest to continue the prosecution of this individual. The first stage is often a bail hearing stage. So another Crown, or the same Crown, will look at the file to decide, is this an individual that can be let out on agreed upon terms with defense counsel and Crown counsel to let this person go without having a bail hearing? Or are our concerns high enough that we have to have a bail hearing for this individual? After the bail hearing stage, whether or not an accused person is detained in custody, we now, as the Crown, look to this case to see, is it going to be resolved? So will there be a guilty plea and some form of sentencing that's agreed upon between defense and Crown? Or is this going to trial? Because that's the only two ways that a charge will go through the criminal justice system if we're not withdrawing it. And the Crown's role is to guide that file and that charge throughout that system to its resolution, whether it be ultimately the guilty plea or the trial.
Witnesses and victims may have fears and concerns about testifying in court. They may be worried about giving personal information. They may be unsure about understanding and answering questions well. They may be worried about not remembering important dates, times, or other details. These concerns are normal. The Crown Attorney and Victims Witness Assistance Program can provide witnesses and victims with information about what to expect in court and options that may make testifying easier.
We will meet with the witnesses or the victims of these matters and prepare them for testifying at trial. What is it like to give evidence in chief to a Crown Attorney? What types of questions are the Crown Attorney allowed? What are we allowed to ask them? What are we not allowed to ask them? And then in cross-examination, which often leads to the highest level of anxiety for victims and witnesses of crime, what types of questions can the defense lawyer ask them when they're on the witness stand at trial? So we try to prepare them for that, what it's like, example questions, and what they can expect.
A victim impact statement is a written statement that describes the harm or loss suffered by the victim and the effect of the crime on the victim. The Criminal Code requires the court to consider a victim impact statement, if there is one, at the time of sentencing an offender. A person who has suffered harm or physical or emotional loss as a result of the offense can prepare a victim impact statement, as can survivors of a deceased victim.
A victim impact statement is a real powerful tool for your voice to be heard. And you can read it yourself, or it can be read into testimony for you by the Crown Attorney. And it's very powerful to state where you're at and how it has affected you.
The Victim Witness Assistance Program, or Victim Services Middlesex County, can help victims prepare a statement. If you would like assistance, contact information will be provided in the services section of this DVD resource. The Ontario Parole and Earned Release Board decides whether or not to grant parole to adult offenders who have sentences of fewer than 2 years. The National Parole Board handles offenders who have sentences of 2 years or more. The decision to grant or deny parole to an offender is made by 2 members of the board. Members carefully review all of the information on the offender's file and conduct an in-person interview with the offender at a parole hearing. Victims may provide a written submission or attend the offender's parole hearing and give an oral statement. Victims may also provide information to a board case officer who will ensure the board members have the information before making a decision. Because this information is used in deciding whether the offender will be granted early release, the offender may have access to any information provided by victims and will be present if an oral statement is given at a hearing.
I had the right as a victim to attend his early release hearing and speak directly with the parole board members. I did that. I went, and the information they gave me is, one, they were exceptionally happy to meet with me, and they were very impressed at my courage, and they wanted me to know at that point, and this is going back 8 years ago, that typically when they saw a woman come before them, she was there to plead for release of her husband who was incarcerated because she needed him to be at home to help her with her family. And I said, I don't need him to be at home. I need him to be accountable.
The parole board is interested in knowing about the physical, financial, and emotional impact of the offense on the victim, the ongoing impact, and any conditions the victim would like the board to impose if the offender is granted release.
I didn't feel, when he had imposed a lifelong disability on me, that he should be let out early. We had not been in any counseling. My kids were having nightmares. I was having nightmares. I felt that what sentence had he served at that point as far as retribution to us, that the only way he was going to give us retribution was to pay society a price. That's what our justice system says. And I think I spent maybe 15 minutes with them, and I don't know how long they spent speaking to him, but it was a very detailed decision that they made, and the detail was no early release. And that was all the detail that I needed. And they said that me going and speaking to them had a very large impact on their decision.
Victims who wish to attend or participate in hearings must contact a board case officer as soon as possible after receiving notification and request authorization to attend the hearing. All hearings will be held in provincial correctional facilities, and victims or observers will have to go through security screening prior to being granted permission to attend the hearing. The Ontario government has created a fund to provide victims with some financial assistance to attend parole hearings in Ontario. For information related to the fund or to speak to someone about Ontario Parole and Earned Release Board's policy concerning victims, contact the board case officer. On your screen, you will find the contact information for the location nearest you. Victims are able to receive information about the offender while in prison in a federal correction facility or on probation with the National Parole Board of Canada if they so desire. Write to the National Parole Board regional office serving the area where the offender is imprisoned or under supervision. Any regional office may be contacted to find out where to direct the request. Use the Request for Registry of Decisions form available on the National Parole Board website at www.npb-cnlc.gc.ca. For more information, contact the National Parole Board office nearest you. Please note the contact information on your screen.
I supervise offenders in the community on probation orders that are supervised on parole certificates or that are bound by conditional sentence orders, otherwise called house arrest. The offenders report to me in person on a regular basis, and my role is to ensure their compliance with court orders. So my role essentially is completing an assessment with the offender when I first meet them, and that assessment process is ongoing and takes a period of time to gather. This allows me to make the appropriate referrals for the offender to attend in-house programming, rehabilitative programming, and any other programming that the probation order or conditional sentence order parole certificate mandates.
A probation and parole officer's enforcement role deals with the following.
If the offender is non-compliant with the court order, my role is enforcement. So that might take place through a verbal caution, a written caution, or a breach of probation charge, which means the offender returns to court.
Probation and parole officers also work very closely with the victim and encourage victims to stay in close contact with them as well, especially if they have concerns.
If I'm completing a pre-sentence report for the courts, I'm going to contact the victim by telephone, and generally that telephone conversation consists of me learning about the information that the victim has to provide me for the courts. It might include things like the relationship the victim has had with the offender, if in fact there has been a relationship. It might also allow the victim to have some input into the court report that I'm writing. After the offender has been placed on a period of probation or sentenced in court, my involvement with the victim is ongoing and intermittent. My first contact with the victim is to explain the probation order to the victim if, in fact, there are conditions that refer directly to the victim, such as a non-association condition.
You know, he has conditions, and they are to not be on my property, to not contact me directly or indirectly. And when I found out through one of my children that he was driving by our house, it was a call to probation and said, one of my kids says he's driving by, and I'm not comfortable with that. I don't live on his traveled path, and he that was addressed with him.